time. Charlotte's running a webinar today with Anita and I hosting, more so Anita. I'm just doing a warm intro. There's been some payroll changes that Charlotte thought was essential that each of you employers knew about in detail, so you can make your own decisions about how you want to apply it, because when you get through the presentation, you'll understand it's not straightforward and there's a few little nuances to it that are going to mean you're going to have to make your own personal decisions one-on-one, that we're happy to talk to you about one-on-one as well, but this is more of a general information guide. So I've got Nita here with Charlotte hosting and otherwise. Nita, do you want to have the presentation goes well? I hope everyone's well.
Okie dokie. Well, I haven't got much to say. I'm going to hand over to Charlotte. Most of you all know Charlotte,
page down each time.
Who's our accountant, heads up bookkeeping, but also does accounting for us, looks after all of our bookkeeping clients' payroll. We actually use the resources of EMPLOYSURE ourselves to get this sort of information and advice from, and do highly recommend them. But yeah, as Adrian said, these are things that we can't make the decision for you, but we do want you to make an informed one. So I think with that, we'll hand over to Charlotte.
Okay, thank you. Good afternoon, everyone. Did you want to just skip to the next slide for me, Anita, please?
Sure do. Yep.
Okay, so there's two topics that we're going to be covering today, and the first one is some changes in regards to personal carers leave and how it's to be accrued. Go to the next slide for me. Thank you. Okay, so a lot of you might know personal carers leave as sick leave, which is what it used to be referred to. And as you would all be well aware, full-time and part-time employees are entitled to 10 days of this leave for each year of employment. And as it says on the screen, awards, contracts, various documents that you might have can set out different entitlements, but this is the minimum across the board entitlement that every employee's entitled to. Next slide, please. Okay, so in the past, and as is the case with annual leave, and is still the case with annual leave, it has been accrued in hours, and ordinarily it's also accrued based on the number of ordinary hours worked in a particular pay period. So as you can see, we've just got a little bit of information here about sick leave or personal carers leave in general and when it does accrue. So it starts building up from the first day an employee starts with you, carries over at the end of each year. It doesn't reset for the most part. In general standards, again, that can be different for certain industries, but for the most part, it carries over. Oh, can you just go back? Thank you. So generally, if you're paying your employee, they're going to accrue leave. So if it's a public holiday pay, paid leave, long service leave, all those sorts of things, that's when they accrue leave. If they're on unpaid leave, they're not going to be accruing any sick leave. And you can see we've just got a little list there of the type of unpaid leave they might be on that they wouldn't accrue for. Next slide now.
Sorry.
Okay, so this is where we come to the important part of this. So in August last year, there was a decision made by the federal court in a case that was before them, and you're welcome to read the details and whatnot. I'm just going to summarize. Basically, the decision made was that personal carers leave needs to be accrued in days, not hours. Now, almost immediately, an appeal was put in against this decision, and the High Court has granted the appeal, as you can see on this slide, in December last year. But as at now, we haven't really had any definitive information on how that appeal is going. So as we stand at the moment, the law is, as was handed down in that case, that we need to be accruing leave in days, or personal carers leave in days. Next slide, please. So this is just a little summary of what the decision was. So I'm just going to read these bits out. So full-time and part-time employees are entitled to 10 working days of paid personal carers leave for each year of employment. The leave protects those employees' income when they are entitled to be absent from work. I'll summarise a little bit. The leave must be calculated in working days, not hours. A working day is the portion of a 24-hour period that an employee would otherwise be working. An employee's entitlement is expressly based upon time working for the employer and is expressly calculated in days. For every day of personal carer's leave taken, an employer deducts a day from the employee's accrued leave balance. If an employee takes a part day of leave, then an equivalent part day is deducted from the employee's accrued leave balance. So basically all that is saying is we cannot any longer accrue in hours, it has to be in days. And when an employee takes a day off, I'll do an example later that'll show you how it works, but when they take a day off, it's just a day deducted, or if they take half a day, it's half a day deducted. So that's the way that we have to work it at the moment. If you want to go to the next slide, please. So there's been a lot of, I guess, discussion, debate, if you like, about whether we should start doing this or not, given that it is still being appealed. So you can see on here that as of the 13th of the 12th, which is sort of the most recent formal communication about this, this is the law that applies. So the appeal is still in motion. We don't know how that's going or when it's going to be finalised. So when this all came to fruition last year, we spoke to our employment specialists and they sort of advised us, just leave it, it's being appealed, we'll see, we'll see how that runs its course. But given that it's still going on and we still don't have any sort of communication or anything formal about where we sit with it, we've recently been advised by our employment specialists that it's something that we really need to give some serious thought to following. So over the past couple of weeks, I've been doing a lot of research about how to apply it in, and for the purposes of this, we're going to talk about Xero because that's what we use for all our payroll clients. I've been doing a lot of research trying to figure out, can we do it in Xero? How do we do it in Xero? And basically the answer is we can't do it in Xero at this point in time. Xero still can only accrue and display leave in hours. There is a little workaround, which is what I've written in that last bit on that slide there, which is we can, I guess, do our best to be seen to be doing what we need to, sort of accounting for it. The way Xero likes to talk about it is accounting for it in days, but when it comes down to it, we still are doing it in hours. But I'll go through a little bit of that in the example that's coming up. Thank you. So I just wanted to share with you, this is a response from Xero that I found on their website, and I got an almost identical response from them when I emailed them directly. And they said, while we're aware of the current decision made by the Federal Court of Australia to change the way the law requires personal leave to be accrued, as you may be aware, this decision is being appealed. At this point in time, Xero Payroll has not changed how our default leave types are set up, though we will continue to monitor this closely. For now, we suggest discussing with your financial advisor and seeking legal advice to help determine what this means for your employees' past and future leave accruals.
Oh, nice.
So basically what Xero is saying is, because the decision's being appealed, they are not going to invest the time and money to make any changes to Xero just yet. They're going to wait and see the outcome of the appeal. And we can understand where they're coming from. I'm sure it'd be quite a costly, difficult process to go through to then only have the decision be repealed. However, it leaves us in a bit of a difficult situation where the software isn't giving us what we need to comply with the law, and hence why we're here discussing this today.
I like the way they wanted to discuss it with us and legal advice. At the end of the day, we don't have a crystal ball. Is this going to come to fruition? Is it not? Who knows?
Yeah, well, none of us know, and hence why this is something that we're going to have further discussions about, and why we're leaving it out there for you as business owners to have a think about and potentially seek further advice on as to what you want to do. Next slide.
Ultimately making your own decision and us assisting you with whatever that decision would be, because I don't feel that I could tell you what to do even if I'm doing it one way.
Exactly right. Okay, so I've just done a little bit of an example, just, I guess, to show you how this can become a problem in terms of keeping accurate records. So you just hired Sarah as an employee. Sarah works part-time and her standard hours are 65 hours over her fortnight payment period. As we've just discussed, Sarah is entitled to 10 days of paid personal leave per year. So, and when we come to this line, this is what I'm talking about in terms of accruing the leave. One thing we can do to try and fit in with the new requirements is, instead of accruing on ordinary hours worked, you can accrue at a standard fixed rate across the whole of the period. So for Sarah, Sarah's paid personal leave accrual in hours will be 2.5 hours per fortnight, because she's entitled to 10 days of paid personal leave, which is 65 hours. That's her fortnightly, her 10 days, if you like. So 65 hours divided by 26 means she accrues 2.5 hours per fortnight. So although we're still accruing in hours, we're doing the accrual in the way that you would do if you were accruing in days. So if we consider Sarah's sick on a Monday when she normally works from 9 to 1. So she needs to have 1 day of leave deducted from her balance, which, if we're going to convert to hours for the sake of how Xero is currently recording, would be a deduction of 4 hours. And Sarah's overall accrual will now be 9 days. Next slide, please. If instead Sarah only took off from 9 a.m. till 10 a.m. on that Monday, then she'd be taking off a quarter of the day and would have 1 hour deducted from her leave total in Xero. So her overall actual accrual in days will be 9.75. So that's all fine. That's all pretty simple, basic. You can sort of make the hours equivalent to days. However, if we look at the next part, Sarah gets really sick, uses most of her personal leave. She currently has 1 day accrued, which is showing as 4 hours in Xero because of the way it's all worked with all the time she's taken off. So she needs to take off another day, and this day is a Tuesday when she would normally work 8 hours. She's entitled to take this day because she has 1 day accrued. So her personal leave accrual in days will be Xero now. However, she only has 4 hours showing in Xero. So her balance in Xero will now become -4. And I know most employers don't usually allow you to go into negative. So if we were to go by the hours, she'd only really be able to take off half the day. However, going by the days, she's more than entitled to take off that whole day. And that's where this becomes difficult, because you can't just make days and hours equivalent. You really do need to have the day balance to make sure. And as I said in this little bit under, it's going to be difficult to ensure that leave is not over-provided or potentially also under-provided without keeping a record outside of Xero as to the personal leave balance in days. So this is where it makes it really difficult. And hence this slide where we said, as a business owner, you will need to make the decision about, firstly, how are you going to account for paid personal leave given Xero doesn't have the capability, and probably other software providers doesn't have the capability to record days yet. And also, do you go back to the 13th of December and adjust your accruals from then? I mean, may very well be it doesn't make a lot of difference, but it may. You know, it's going to depend on everybody's individualized circumstances. So for our payroll clients, so the ones that we process for, we will need to have a one-on-one discussion with you about this once you've had a chance to think about it, research, potentially seek specialised legal or employment advice. So that's something that we'll probably have to do once you've had the time to think about that. Okay, so that's topic 1 for the moment. Topic 2 is another decision of another case that's quite recent, which you may have heard about in the news. If you want to just go to the next slide for me. Yep, thank you. So this is another federal case, and this is in regards to casual workers and their entitlement to leave. So there was a landmark ruling that has confirmed in some circumstances, casual workers, and we put casual in inverted commas there, and you'll see why as we go through it, can still be considered to be a permanent employee despite there being a contract of employment stating otherwise. And so therefore, as permanent employees are entitled to entitlements, annual leave, sick leave, etc., there is a potential for casual employees who fit under this mould to also be entitled to these entitlements, both past and present. So there is a retrospective nature to this decision, which is very a little bit subjective and up in the air at the moment. We'll look at that on one of the upcoming slides. But
grandfather clause.
Yeah, pretty much. I'll just read this little bit here. In the federal court decision, it was determined that casual workers engaged with an advanced commitment of work on a stable, regular and predictable basis for an indefinite length of time were permanent employees and could be considered permanent employees, which meant that they should have accrued and or had access to various employment entitlements, including annual leave, personal leave, paid compassionate leave and payment for public holidays. So as you can see, if any of you do have casual employees that you feel might fit under this category, it's really important to determine whether they actually do or not, because there's a big potential for liability, especially considering it is able to be retrospective potentially.
Do we have a date of when it can go back to, Charlotte?
I have not seen that, and this information that we've got here was taken from some advice received by our employment specialists. I don't believe that they provided any sort of dates, and this one's a little bit more up in the air, I think, because it's quite new. What we've given you in this is pretty much all we've got, and it's a little bit vague, so we'll have to keep doing some research on that, but I couldn't find dates. Sorry?
The scary part there is because it says past employees.
Yes, correct.
We have a date from when that past employees have been considered.
Well, it may be that it depends on when they are considered to have become permanent. So, you know, if they're literally making it retrospective, then it has the potential to go back to when they started with you. Maybe it would be my way of looking at it. But again, that's a very legal question that we'd need very specialised advice on. All right, we'll go to the next slide. Thank you. So one of the important parts of this, and I'm not going to get too much into this because, again, it's more of a legal definition.
Charlotte, we covered this very recently with having to determine for JobKeeper and all the rest of it.
True.
Was whether it was regular and systematic. So I think for most of us, we're all pretty well over that.
Yeah, the only thing I wanted to say was the basic way of looking at it is if the way that they're working is more like a permanent part-time employee, then it's quite possible that they fall under this bracket of casual employee. Just as a summary, so we can skip past that if you want. All right, so the natural question that then comes up is, what about the casual leave? The casual loading. Doesn't that cover all of this? And one of the important parts of this case is that they believe that no, it potentially doesn't cover that the loading is not enough to cover the entitlements that they would have been entitled to had they been considered a permanent employee for the time that they should have been considered a permanent employee.
So it hasn't yet been established whether you can potentially offset the additional income that you paid them for the accruals that they could be getting.
Not as far as I'm aware, and I think it covers it if you go to the next slide where it talks about double dipping, I think. Yeah. So I'll just read this. Many employers believe that casuals who are receiving the loading plus entitlements are double dipping as the additional remuneration should be in lieu of the entitlements. But it really, that's all we're sort of getting, is this maybe, it may not cover it. I don't think there's a lot of definitive information out there about this thus far, or certainly not according to what's been provided to us. But the general consensus is that no, it isn't double, or it isn't sufficient, but whether or not it means you're less liable for full entitlements, I couldn't comment on that. I don't know the answer.
You'll be entitled to make a calculation.
Yeah.
Okay, next one.
Next one.
Can't do it.
Okay, so how do I ensure I don't get caught by that? So I'm just going to read this out. Given the retrospective nature of the decision, it might not be possible to protect against past exposure. In these circumstances, this is EmploySure because that's who we use. They recommend that you seek formal advice, and we do the same. It's going to be a very individualized thing that you're going to need a legal specialist for you to present, say, I think maybe it might apply to this employee. What are your thoughts? You know, what are our requirements? And I'll just read this. Moving forward, in light of the uncertainty, businesses might consider refraining from engaging staff on a casual basis in circumstances whereby it is intended that they will work on an ongoing basis and their hours of work can reasonably be predicted in advance. And that's just to avoid getting caught under this new way of looking at casuals. If this is not feasible, you should consider ensuring that casual contracts of employment contain an appropriately drafted offsetting provision and a separate clause permitting restitution in circumstances whereby the employee is considered to be permanent.
Oh, so they're trying to write it into the contract that you can offset that 25%. That's interesting.
Yeah, so how that would work from a legal perspective, I'm not 100% sure, but it's an option to look at. But obviously that's going to be for new contracts. It's going to be the old ones that are going to be the problem.
Yeah, but it's definitely wise to have that in there, because even if you can't stand on it or fall back on it, at least it's there.
Absolutely.
At least it's maybe a little bit of comfort for you.
Exactly.
As you say, moving forward, not retrospective.
Exactly right.
Next
good? Slide. Pretty much, I think. If we go to the next one.
On the screen.
Oh, sorry. Yep, there it is.
Yeah. So that's basically it in a nutshell, just a brief overview. If you have any questions, let us know.
Pop them in the box and I can ask Charlotte. But yeah, it's scary stuff, really. It's just change everything that's been for the last how many years?
Yes, well, that's exactly right. It leaves us in a very ambiguous situation where we're not 100% sure of what to do.
No, and that's hence why we're sort of saying, hey guys, here's the information. Act as you feel appropriate, because there's no clearly defined right or wrong. I would probably say we're going to calculate what the difference would be, so we know where we're sitting at. I mean, obviously the casual law will have to go to, the casuals will have to go, because we do have some, particularly uni students, because they like changing their days. So they don't want to be particularly locked down to particular days and all the rest of it. But granted, they tend to work the same sort of hours. We'll have to get some advice on that. And yeah, and as for the other one, I think what we'll do, Charlotte, I've done it with you in agreement, is we'll probably just calculate what the difference is between what's happened since December to now, and see what impact it has on the leave.
Yeah, well, I think basically what you're going to have to do is calculate it in days as at that date, and then adjust the accruals. It's just going to mean that you're going to need definitive information on schedules, which is going to be tricky, not so much for us necessarily, but for some people.
Okay, so you've got a question here, Charlotte. Hi Mark, how are you? Hi, I have a school bus run and the hours are set each year and my driver is currently casual. Would this mean that he would be permanent?
It's a possibility. Again, it's not something that we can really answer. You would need a legal employment specialist to confirm that to you, but looking at what the rules are and what the guidelines are, I think that is possible.
Yeah, agreed. I mean, just looking at it, you'd say, very highly likely. Yeah, go on.
I don't want to overreact to everything either. We've got to try and find something in the middle. It's a tricky situation. It's no different to a case that happened in the courts where everyone was questioning whether trusts were valid and all that sort of stuff. Correct. And they ended up appealing it, but it took about 2 years for that to settle. But what a lot of people back then is they still kept going as if that was the right way to go, because that was the general advice. I'm not saying that's the case here, but we don't want to overreact without getting a bit more advice, I don't think, because what happens if we go and make all these changes and then they end up winning that?
Yeah,
You
and
know?
that's
right.
That's what I'm sort of saying. Maybe calculate it so you know what your differences are, and so you sort of know where you're sitting. And also moving forward, if you don't want to change retrospectively, like Mark, you don't want to change your situation with your casual, or maybe it is beneficial to move them over to permanent. Maybe it is a win-win. And then maybe that will help ease the past and we won't have to deal with it. But just moving any future casuals, like what you've got here, put that clause in there. Who knows it's going to help you or not, but at least it's there. At least we go into the situation knowing what's out there, if you know what I mean, knowing what the situation is as a business owner. So it's not like we go off willy-nilly and we hire casuals and we're unaware of this and it comes back and bites us in the bottom. And that's all we're really trying to do here, guys, is not scare you. I mean, there's always crap flying around, but just so you can make informed decisions, so you know the circumstances. There's no nasty surprises.
But don't panic either.
Yeah.
We've got to take our time and take advice and think about this, and we'll all be there to guide you through and make some practical decisions.
Yeah. Yep. Is there any other questions? No. Alrighty. Well, we might just wind that all up. I hope that you guys have.
Oh, hang on.
Sick leave, is there a total amount of days accrued, or is it 10 days each year? Just 10 days each year, isn't it?
Just 10 days each year. Yep.
It's not just sick days. It accrues. You covered that before, didn't you? It's not just sick leave. It's other bits and pieces. Personal carers leave and all that.
Sick leave is 10.
It's, so personal carers leave, sick leave is all the same thing, and it's just a simple 10 days per year.
Yep. So if there's any other questions? No. Well, thank you everyone for attending. Thank you very much, Charlotte, for that information. I'm sure you're going to have a few more consultations. Yeah.
And we'll be sending this out to all our business clients if you guys have any questions, because a lot of people couldn't come on because of the time of day it was, and that's fine. Feel free to contact us and organise some discussions one-on-one once you get a chance to digest what's in the webinar.
Yep. So I wish you all well. And as we all go into lockdown again.
Well, for Victoria, not everyone.
Melbourne, yeah.
Sorry, some of you aren't. Yeah, exactly. Feel for us. Have to go into another 6 weeks of lockdown.
But take care, guys. If you need us, we're here for you.
Yeah. Take care. Thank you, Charlotte. Thank you.
Thank you.
Bye.
Bye.